Hello everyone, welcome to another interesting episode of Munches and Thoughts. My name is Phathanani, I am your chef. And of course, I am not alone. I'm joined by you, my friend. Welcome back!
Thank you, my friend. I'm happy to be back.
And it's good to see you again.
Thank you. I see we're having orange juice today with our nice muesli, as opposed to the usual. Today we are drinking
My
Crush
darling,
orange
today
juice.
I decided that let's have Crush. You know what Crush is doing? Crush is giving us, the dreamers, an opportunity to show our work to the world and the universe as large. As you know that, I would love to see Munches and Thoughts going beyond this. So that's why I said, let's enjoy my Crush.
Okay.
On camera today.
All right.
As I always enjoy it out of camera, but today, let it do it today. And the nice thing, what we'll be talking about today doesn't need any liquor, darling. Please introduce yourself. Who are you? Where are you from? What's special about you?
Thank you so much. It's always a great pleasure to be here.
Thank you.
My name is Tshepang of Tadelo Attorneys and Conveyances. Our offices are at Office 405 Olivetti House.
Okay.
237 Sophie de Bruin Street. In Pretoria, we are in the CBD. Our office number is 071 831 8795. Another number is 012 880 3831. So we are readily available for anyone who will have interest in consulting and seeing us after this show.
Thank you so much, my darling. And most of you, you know Tshepang from Tadelo Attorneys.
Definitely.
I call her Dr. Did and Dr. Cindy Waliga.
Oh my God.
And welcome, my darling. Thank you so much.
Thank
Today,
you.
we are discussing everything properties, deeds.
Yes.
You can name it. You
Yes.
know them. It's your line of work.
Definitely.
So before we go far, or before I start posing questions, can you please give an overview? What is it that we are talking about? So that whoever that is watching can be able to follow us.
Definitely. Today, I particularly want to touch on issues, or rather processes that become involved in purchasing properties, right? We are conveyancers. Conveyancers are lawyers that deal with property transfers, property registrations. It does not necessarily have to be transfers, but we deal mainly with properties. So whenever anyone becomes interested in buying and selling of houses, conveyancers become involved. So I am here today to discuss formalities regarding it, processes regarding it, the do's and the don'ts, and basically enlighten everyone, about what goes down when we actually say we are transferring your property.
Oh, wow.
Yes.
Nizwileke, namhlanje uTshepang from Tadelo Attorneys, she is here to assist me and of course you as a viewer. The do's
and the
don'ts.
Yeah.
So, kuningi esikhuluma ngakho namhlanje?
Good, you know what, my friend? Help me.
Kuningi.
Oh, kuningi. Yes, it's a lot. Kuningi, it's a lot.
Okay.
Yeah.
So, Tshepang, can you tell me here, who are the role players in a property transaction? Basically, who is who in the property transaction? You spoke about transaction.
Yeah.
So now I think you need to go deeper to explain what is it that we are transacting
in,
and then how did we get there, and then the rules and the do's and the don'ts.
Okay, my friend, this is where I'm going to start, right? We are going to start with the role players. Who is who in a property transaction? Okay. Now, you decide tomorrow that, look, I'm Phathanani Mbatha. I want to buy my house in Copperleaf. And this is what I want, the specifications that I have regarding this house. But basically, you want to buy, right? When you're buying, there has to be someone who is selling, right? So there's the seller, the role players. Now we are just dealing with the role players. There's a seller, there's a purchaser, right? There's someone who could be marketing the property.
Oh, so that person.
Yeah, there could be. I'm dealing with people that become involved in the transaction now. Okay. It's a buyer, it's a seller, it's an agent. An estate agent is a person who markets the property. It's the one who's given a mandate. We say agents are given mandate by sellers. The seller goes to the agent and say, look, I have a property that I want to sell. Can you help me find a buyer? Okay. An agent comes on board. It's you on board as the buyer. It's the seller on board. It's the seller who has appointed an agent who comes on board as well.
So who appoint the agent is the seller?
Is the seller,
Okay,
yes.
okay.
But there are instances where a seller does not come into play. Those will be instances where the seller already knows its own buyer. They don't need to procure services of an agent because they already have a buyer.
Okay,
You understand?
okay.
I'm just giving you, in most cases, this is how it goes, right? And there will be, the agent will have an agreement. We will get to the agreement, which is an offer to purchase signed. And then once the offer is signed, takes the offer and gives it to the conveyancing attorney. The transferring attorney, being the conveyancer, gets the contract. Now we have a conveyancer. We have a fourth person now, right? The conveyancer now looks at the transaction, looks at whether there will be a need of a cancellation attorney. Cancellation attorney meaning the transferring attorney will check. Okay, did the previous owner have a bond or not on the property? Okay, if the previous owner had a bond, it means the bond that is existing on the property
needs to be cancelled.
Now we have a bond cancellation attorney in play.
So now we've got the fifth one.
Now we've got a fifth person, a fifth party.
This is a chain, but anyway,
yes, it's a chain. It's a chain.
Yes.
These are the role players, right? And then there's a bond cancellation attorney. Now, depending also on how you buy the property. If you're going to buy the property cash, that means you don't need to apply for a bond, right? That means there's no need for a bond attorney.
Okay.
But if you need finance, that means you're going to apply for a bond. Now we have a bond attorney. We are at number 6. We have those role players. Now the conveyancer also.
Okay, so now, sorry.
So
these
now,
6 role players.
They are all important on the transaction.
All important
on the transaction.
Okay.
The bond cancellation attorney and the transferring attorney, they go together.
Okay.
When we lodge at the deeds office, we lodge together. We are transferring the property from A to B. The existing bond must be cancelled and a new bond must be registered. They are all together.
I believe it's money, all these things.
These things are all money, but different people pay for different things, right? We haven't even gotten to municipalities. We haven't gotten to SARS yet. They're also part of the transaction.
Okay.
They're also part of the transaction.
This is so interesting and very important. I hope my viewers are listening, and I hope my viewers, they will learn a lot after this episode.
Yeah, they will.
Wow. Okay.
They will learn a lot because definitely people are so people are not clued up with actually what goes on. You know, they just sign, and after signing of documents, they think the next day they'll be having a title deed ready for you to come and collect. There's a lot of back and forths that happen in a property transaction. The conveyancer must make sure that when you enter into your property, the property doesn't have an existing debt with the municipality.
Oh, okay.
Meaning, we need to go and consult. We need to go and get readings on the property, consult with the municipality, get clearance figures, have those figures paid by the seller because it's the seller's debt. Make sure that the seller pays everything that is outstanding to the municipality, get a clearance certificate.
Can I ask you something, Tatelo? So you are talking about a municipality now,
yes.
And maybe if there is any existing debt,
yes.
the seller needs to make sure that debt is cleared. So what if I don't have that money to clear that debt? Then I made arrangement with you guys, which this is, maybe I'm selling my house with 200,000.
Yeah.
Maybe the debt is like 5,000. Okay, guys, on this 200,000, you can deduct that 2,000
or to just
or
pay
5,000
to
pay this debt.
Yes.
Is it possible?
It is possible.
Oh,
we have. That's why conveyancing firms work with some bridging companies. We have companies that bridge for us. They give us finance. We tell them that the transaction is at this stage. We have guarantees or we have this cash in place. Can you please bridge for us? Assist us. The seller must be aware that we are bridging this amount of money for him so that we can pay the municipality. And then when we bridge, it means that the seller has to pay back the bridging company with a little bit of interest because it's a loan.
It's not you guys who
No, it's not us. We must loan the money from the company.
Okay.
The seller must sign to bind himself that should anything happen in the transaction, the seller will be liable to the bridging company to pay back the money that they could have loaned us to be able to finance the outstanding debt.
You know, I just learned so much from this little bit information.
Just
And it's exciting and very important.
It's very, very,
so
very,
yes,
very
yes,
important.
Proceed before I go.
It's very important because you know what happens. We deal with this every day. Sellers don't want to pay the municipality. When we say to a seller, we need this account to be paid up because unfortunately the new owner cannot take occupation or have the property registered in their name with an outstanding debt. They think we are trying to get them to receive less than what they had expected. You understand? But the municipality has to be paid. I want to put it in record. The municipality needs to be paid whatever is outstanding so that we can get our clearance certificates. Now, there's another role player that becomes involved here.
There are many role players.
There are a lot. If your property is within an estate, you need to pay body corporate levies. Meaning the same way we pay the municipality, we clear the municipality, we must clear the body corporate.
If you are owing.
The body corporate will calculate to say the transfer will most likely take 3 months. We are going to put clearance figures for 3 months in advance. Pay these figures 3 months in advance. Should you register early, we will do a refund. That's how it works. Even with the municipality, it's calculated 3 months in advance. And then should you register early, the seller can get their refunds. It's to secure the purchaser throughout the process so that we don't register and there's anything outstanding.
So even if I pay that money 3 months in advance and for body corporate and municipality, then I decide to cancel this.
That means your account is in credit. If you are cancelling as a seller, it means your account is in credit.
Oh, wow. I don't know. Before I go to the second point, is there anything you want to say?
No, those are basically the role players. There's also SARS. The last person is SARS. If your property is above R1 million, there is a duty, transfer duty payable to SARS. Anything above R1 million, you need to pay SARS. Anything below R1 million, no transfer duty is payable.
Okay.
Yes. So you with your copper leaf house, you are going to pay transfer duty.
It's fine, darling. Thank you so much. You mentioned very important thing. I hope my viewers, they've learned, and I hope my viewers, they heard you, because I didn't know about these role players.
And you know what is also important, Phathanani, it also prepares you as an individual when you sell to know that there will be monies that are required. So you need to be not only mentally ready that you are selling, but financially ready. Even financially ready for the buyer, because the buyer must pay conveyancer's costs.
So the seller, you need to be ready when you are selling.
For your municipalities, for your body corporate levies, for your homeowners association levies, you need to be ready.
You know, nothing comes easy, but it's okay. Anyway, okay, tell me, how does the property sale commence and what is exactly included in the sale? I hope it's going now, it's linking now what you just said.
No, it definitely links. Remember now, these are people that the role players are people who become involved.
Yes.
Now we are talking about the beginning.
The beginning.
The start of things.
Okay.
The start of things meaning that I've been saying transfer, if you can hear me.
That's what I want to hear now. Because when you're saying transfer, I'm thinking of transferring money to you or to whoever.
Transfer means moving of ownership from one person to the next.
Okay.
We are moving ownership from A to B. That is what we mean when we speak in conveyancing terms when we say transfer. Now, when we move ownership from A to B, the end result of B is that there has to be a title deed. Okay. That is proof to B that B is now the new owner of yes. We would have transferred. The end result evidence for B is a title deed. Fine. Now, the beginning part of everything is that there is no immovable property that can be sold without an agreement of sale. There has to be, an immovable property has to be in writing. The sale agreement has to be, the sale has to be in writing.
Okay.
And the agreement must highlight who is who. The agreement will say who's the seller, who is the buyer, what is the purchase price, the property description, which property is being bought, and all conditions that are going to govern the sale, whether it's going to be cash, whether it's going to be by bond, all of that is going to be in writing.
And then who writes that?
It can be an agent who usually would have their own agreement of sale that will be at their company.
Okay.
Or if you don't have one as a seller, and you already have your buyer, you can go to a conveyancing firm and say, look, we want to do this whole change of ownership. As a conveyancing firm, we have agreements of sale that we prepare for clients. Yes, that they can, so that we can commence the process. Without an agreement of sale, you cannot start the process of change of ownership. You understand? Sure. Now, at home, people at home, I want them to understand that an affidavit from the police station is not an agreement of sale.
Okay.
Maybe should the matter go to court when there are disputes, maybe their affidavit can assist them. An affidavit that they sign together, they give each other money, then they go to the police station and say, I, Tshepang Thatelo, say I have sold you 1, 2, 3. That will not suffice. That is not a title deed. That will not take them anywhere. Except what should a dispute arise, maybe it could end up in court. But please, properties are not sold by the affidavit. Agreements of sale are prepared and they are taken to the attorney, the conveyancer who's going to start the whole process of getting clients to sign, communicating with the different role players I've mentioned, and eventually have the transaction go to deeds office so that the end result can be a title deed.
So let's meet somewhere,
no.
And then let's finish this. I'm selling you this house,
and I'm giving you this much.
This is the amount.
No.
Take it and then take the house.
It's extremely risky. That is why we see people fighting. That is why we see some houses actually, the disputes become so bad that the house in dispute becomes even bent down. Nobody actually gets to know who bent the house down because the disputes are so rife. You understand?
No.
So because things were not done properly, your municipal statement, Phathanani, your municipal statement that you get from the municipality, it does not prove ownership, because there's a misconception in communities that statement sa masipala se bitsa ka nna go tsho ntlo ela ke yaka. No, the municipal, you see that address where your name is written, it is just for the municipality to see who is responsible for that account. It does not mean ownership. We are going to get to estates, ne? Your letter of authority, it has nothing to do with owning the property. It means you are responsible for administration. You are not an owner. People will be fighting, but as a result of lack of knowledge. You understand? That is why we must enlighten everyone. So the process starts with an agreement of sale, which goes to the conveyancer, and then the conveyancer is the one who's going to interrogate everything. Then conveyancer will do a deed search to check, is this owner really the one appearing on the deeds office records?
Yo, Babukela Makaya, Nizwile Tshepang from Thatelo Attorneys, she did mention that a letter from municipality, Aigwenzi, the owner, your property. Letter of authority, Aigwenzi, the owner, your property. That's why we find people killing each other. Yes. That's why we find people threatening each other because of things like that.
Of course.
Guys, seek knowledge. Seek advice from conveyancers, people who understand, and that I don't think you guys will mislead them if they come in looking for information. No,
we cannot mislead. It's very difficult to mislead an ownership issue, Phathanani. As I was saying, right, that as a conveyancer, you have a seller that is in front of you bringing their FICA documents, meaning their identity documents, which you must match with the deeds office records, right? So it's not easy to mislead, because the deeds office record says Tshepang Thatelo is the owner with this particular identity number. The person that has to sit in front of you has to be Tshepang Thatelo with that identity number, with the original title deed. Unless if the house has a bond, the title deed will be with the bank.
With the bank. Okay, but now before we go further, tell me, I believe that there are those people, Bagdala, who don't have title deeds. If they want to sell their houses or their land, what is it that they need to do?
How do they not have title deeds? What do you mean they don't have title deeds?
You'll find what's in Islam Makaya, I'm a title deed saying in Dala, or the house was owned by my grandmother or my grandfather, and then there's no title deeds, but we've been staying there maybe for 30 years, 40 years.
You know what? When we deal with registrations of properties, there are properties which are registrable. We say these are registrable properties. These are properties that have title deeds. And there are properties which do not are not registrable. You find that those properties are tribal land, right?
Okay.
They have what they call PTOs, permission to occupy. Us as conveyancers, we don't become involved because we cannot attend to registration of those kind of lands. They are administered by the communal, by the tribes that manage that particular
the
land.
Kings and all those kind of
So
things.
there we cannot become involved. We become involved in properties where registrations are done. We don't deal with properties that don't have title deeds.
Oh, okay. No, I think I'm okay. Now you mentioned a lot of transfers today and registrations. Can you explain the different type of properties transfer that's normally,
that normally take place.
And yeah.
What I just explained now was on your normal cash, not cash, like a buying.
The buying seller and the buyer, yes.
Seller, purchaser, right? That one is standard. It happens all the time.
Okay.
Even these ones that I'm about to explain also happen all the time.
Okay.
We have your estate transfers. Ne? Estate transfers there's 3
You see, I'm
scenarios.
even looking at you like
Yeah.
I'm not talking. I know I talk too much, but I'm just listening because this is very important. And
It is
so interesting.
very,
Yes.
very, very important, Phathanani. There's different types of transfers. I'll get to your estate transfers, right? With your estate transfers, you have a situation where I don't want to start to the transfers first. Let me start by explaining estates, deceased
Not a
estates.
problem.
With the deceased estates, right, it means someone who was an owner of a property has passed away. Now, when this person has passed away, it means that someone has to be appointed to now act on the deceased part. Now, that is where the master then gets to appoint someone and you are given a letter of authority or a letter of executorship. Right. Those are letters that are issued by the master. Your role when you are issued those letters is to administer the estate in the best interest of everyone that will
It's
be
not to own it.
You are not an owner. Please. There's no ownership there. You are not an owner of the property. Please. You are just a representative, to do what is right, by the way. And then when you disclose at the master, please be honest. Don't say you are an only child when you know that you have 5 siblings. You are lying under oath. That next of kin affidavit that they make you complete and sign at the master's office, it's an affidavit. And lying on an affidavit means you're committing a crime. You must tell the truth. If you are 5, mention all the 5 siblings. If you mention all parties that were related to you that you feel need to, because circumstances are different, that the master needs to be aware, need to be disclosed. You understand? And then once you die, there's a difference whether you have died with a will or you would have died without a will. When you die with a will, it's great, it's perfect. The deceased has mentioned how he or she wants
everything to be
distributed. Great. But it happens, we see it all the time, there are no wills in place. When there are no wills in place, the law now assumes that this would have been the order. The law assumes that there's a spouse and children. Ne? I'm giving you preference now.
Yes.
Is the spouse and children. In the absence of a spouse and children, let's say in the absence of a spouse, there's only children. Then it moves to children. Those becomes the beneficiaries. Your immediate beneficiaries, your spouse and the kids. There's no spouse, it's the children. If there are no children, it moves to the parents of the deceased.
Or not the wife.
No. Let's say there's a wife. No, when there's a wife, the estate becomes much easier, especially when you are married in community of property.
Okay.
There's a wife. Great. It starts with the wife.
Okay.
Then we don't need to go any further down. There's a wife with kids.
If there is no will.
If there's no will, now we are dealing with intestate succession.
Okay.
Now there's a wife. We don't need to go further down. Stops with the wife. Wife has kids, stops with the wife and kids. They need to be considered when we are distributing the estate. Ne?
Okay.
Wife maybe is not there, predeceased, or the man never married. It's the kids only. It stops with the kids. It means we don't need to go to the uncles and the aunts.
And the grandkids.
And it stops with the kids. Let's say now there are no kids. This person had no spouse or the spouse passed away. Now this person died, no kids. Ne? We must now get to the parents
of the person
of
that
the
died.
deceased.
Yes.
Now we get to the parents. Let's say the parents also passed away.
Sure.
Then we must go to the siblings, brothers and sisters.
By the deceased.
By the deceased. It goes like that. It goes further down. So can you see from where I am? I'm at 4 generations.
Yes.
Can you see the uncles and the aunts are far? Why are the uncles and the aunts fighting with the children?
No, so
Why are the uncles and the aunts fighting with the children? Hiding title deeds of children and spouses? Why are they fighting with their makotis?
wow. Let me say this. Baba Mama Kaya, I hope Nizwile, like I just learned, you mentioned 4 generations. And Abu Malume, Nabo and Abeko, because they fight us. They fight the kids. They fight the spouse. They are
so far. They are so far. They will be considered after so many people are not there. But they are the ones who, in most cases that we see sparking disputes, with the immediate beneficiaries. That is what happens generally now that is the administration of the estate. Now when we have to start transferring, we go with that line. When we do estate transfers, we go with that line. Spouse, kids, parents, siblings. We go in that particular order. You cannot just, when there's no will. But if there's a will, definitely it makes things so much easier.
But if there is none, we need to follow
the bloodline as according to law, because the law assumes that is what the deceased would have wanted.
Okay, but I want to ask you something then. You counted everybody, and then maybe if these people are not there and then it's only grandkids.
Grandkids of who?
Of the deceased.
Grandkids of the deceased.
Remember, we go all round.
Yeah, you must remember. Do you know what happens? What happens is that if, let's say, spouse not there, then there are children, and then with the children, maybe the children had kids.
Yes.
They are going to be represented by
That's what I wanted
they are
to
going
know.
to be represented by their kids. So you don't jump them. Let's say their kids
Yes.
were 5.
Yes.
And 2 have passed away.
Yes.
And there's 3 left.
Yes.
And with these 2 that are left, they have kids. These 2 that have passed away, their kids step in to represent them. So when you divide when you divide the estate, the representation of the kids that have been left step in on this one and this one.
Wow.
Can you see? So it means the minute you move from here, there really has to be no one.
There is a problem.
There really has to be no one.
But I think the problem that we are facing now, they move here, which I don't know how and I don't know why, and then you find kids fighting now. We just counted.
I think
because there are problems.
I think it's honestly some is dishonesty. We've seen a lot of dishonesty, knowing that someone is entitled but they don't tell the truth. But also again, it's lack of knowledge. We are 5 at home. Everyone has passed away. I'm left alone. I believe I'm the sole heir. You don't want to consider the kids of these ones. Because you believe that I'm the only one left, but they are representing their nieces and nephews of your. You understand?
I want to understand now with divorce transfer. Who gets and how and all, because I see a lot of people we read magazines, we read papers, we read, so you're watching television, people are fighting the divorce and all those kind of things.
Yeah. But before we move to divorce, can I just close something on
not
estates?
Not a problem.
What I wanted to also close on estates is to just say that sometimes it's not in all instances where we are going to transfer to the children in the estate or anyone who's benefiting in the estate. So in some instances, an estate property can be sold. And when you sell it, we need permission from the master to agree. The master will want to know who is going to benefit. The master will want to know what is the purchase price. The master will want to know how the monies are going to be divided amongst everyone. So you can sell directly out of the estate without transferring the property from the estate to the beneficiaries, then from the beneficiaries to a sale. You can sell directly, but the children that are meant to benefit will also benefit from the sale. That's all I wanted to mention.
Okay.
Yes.
Proceed to my second point.
Then I can proceed to your divorces. Pata, divorce is a reality. We've spoken about marriages previously. We've spoken about divorces previously. Divorce is a reality, and with divorce, it means that there has to be also a division of a joint estate, right? And then there can be a property involved. Some estates do have properties, others don't have properties. Now, when there's a property involved and you come and you say to me, Mr. Telo, can you please help me? This property is meant to be mine. I was owning it with my ex-wife or ex-husband. The first thing I'm going to ask you is, can I please see your settlement agreement?
Okay.
If I did not do the divorce, right? So I want to see the settlement agreement. The settlement agreement will stipulate that A must transfer his or her half share to B. That's if they were married in community of property anyway. It will say A must transfer their half share to B within a certain period of time.
Yes.
You know, or maybe sometimes settlement agreement does not give time, but it says A is entitled to the property. Or there's 3 properties, you keep 2, I keep 1. So we follow the settlement agreement. Even the deeds office wants to see the settlement agreement. So even if you have a settlement agreement, the court made an order in your favor to say that the property has to go to yours, transfer needs to take place. Meaning you, the other party, who's supposed to transfer your 50% to B, now you cannot refuse and start playing games when you have to come and sign documents, you know, or the settlement agreement says there has to be, what do you call this? The settlement agreement says there must be a sale. The property must be sold. And then you, because you are in occupation of the property, you don't want now to comply with the court order. What you're doing is wrong. You are defying the court order. The court order said there must be the court order, settlement agreement incorporated, it says that the property must be sold. It means you must cooperate. The court order, maybe the settlement agreement says I'm entitled to the share and you are still in occupation. You must get out of the property. It's mine. I must do the transfer has to be done in my favor.
Yeah.
Now, what I want to plead to people is to say that don't sit now with your settlement agreement that says your property is in favor of the property is in favor of you, and you don't attend to the transfer. Do the right thing. Go to the attorney's offices. Come to us. Let us help you. We will do your transfer so that the property can be fully yours. You can own the whole 100% because you're already holding 50. You need to get your 50 back.
Wow. Nizwileke babukile mamakhaya uchazile uThatelo from Thatelo Attorneys that even if you've got a settlement letter that you're entitled to the property or whatever, don't sit at home. Please see an attorney to assist you to make sure that everything is done in order.
Of course.
Okay.
And please, they must cooperate. The other party who has to transfer their share or who has to cooperate through the sale, please do cooperate.
So now tell me, the courts gave me the right to own the property or my share from you. Who is responsible to pay the conveyance's money?
The person who's going to be receiving the property.
Phew. Okay.
The person who's receiving the property must pay conveyancer's fees. In an estate, the beneficiaries must pay the conveyancer's fees. In a sale, the purchaser must pay the conveyancer's fees. It's not the seller. Please, purchasers pay conveyancer's fees, not sellers.
Wow. Nizwil?
Yes.
Let's pay.
Please pay us. Can we be paid? Can we be paid?
Not the seller. Wow. And then, okay. Now I think it's just for me to go in a closing, like briefly the deeds office, the process, how is everything, because you've been mentioning okay, the deeds, I had deeds coming in, so now maybe if you can just give my viewers and myself the process, okay, what is it really, the process, the deeds office and etc.
Okay, so deeds office comes at the end for us.
Okay.
We would have communicated with all the role players. We would have engaged. Remember, this is under normal circumstances. We will say transfers of properties take 3 months. You know.
Okay.
Taking into account there's estate transfers, there's divorce transfers, there's different types. So we usually say 3 months, but obviously when it's a sale, it goes a bit faster. You know, it can be done 6 to 8 weeks. It can be done, especially if it's cash. Deeds office comes at the far end. That is when we go to lodge. When we lodge, there's no bond. I'm just doing a transfer from Tshepang to Phathanani. I'm lodging a loan. If there's a bond, it's transfer and a bond. If there was an existing bond, it's a transfer, bond cancellation, and a bond. We must lodge together. So meaning I must be ready to lodge, the bank must be ready to lodge, the bond must be ready to lodge, the cancellation attorneys must be ready to lodge. We do things all together. So you find clients being angry, saying, transferring attorneys are ready. Why is the bond attorneys not ready? Bond attorneys must get a proceed from the bank. Why are BCs ready? Bond is not ready or transfer is not. We must all be ready when we lodge. We lodge at the deeds office. When you lodge at the deeds office checks. It's for compliance. So they need to tick the boxes. They need to check, is this the right owner? Are there any interdicts in place? Is everything drafted accordingly? Is the clearances in place? Is everything in order? They actually check what we have been doing for the past couple of weeks.
Oh, I think I understand.
You understand?
Now.
And then they examine the deeds. That's when we say it's going through level 1 examination, level 2 examination, level 3 examination. They examine to see the legitimacy of the transaction and to ensure compliance with the Deeds Registries Act, with the Sectional Titles Act, with various acts that become involved in the transaction.
Wow.
And then afterwards, they pass the deed. If they believe that the things that need to be attended to, they will reject the deed. We must fix the corrections and take it back in the system. Ultimately, the deed becomes registered.
Wow. You know, I just learned, you guys are doing a lot of work, basically.
We are doing a lot of work.
Before it can, because people, they will think deed office is the one that is doing.
No, we do
you
the
guys
work.
are doing the work.
We must feed deeds with what we have done. For deeds to say you're on the right track, nope, Tatelo fixed this. This needs to be fixed, this doesn't need to be fixed. But we do the most of the work, which is a lot of work.
I just learned that today anyway. Let's cheers to crash, darling.
Cheers, crash.
Yes. I just learned that when Tshepang.
And then after the registration, my friend, deeds office must update their records. So they must update records. They must show the old owner appearing in the history, have the bonds cancelled, have the new bond registered. They must number the deeds. They must update their records. And then we will have what we call delivery. Then we will get the title deeded.
Wow.
Delivery.
Okay, before I go to my second point, is there any possibility where someone will produce a fake title deed?
You know, one thing I can tell you, Phathanani, is that you cannot compete with the mind of a criminal.
Okay.
When you and I are sitting shooting, they are thinking of ways. They are thinking of ways of trying to, we try by all means. We check these records, we check IDs. It has become honestly speaking, our job has become so difficult because we go now an extra mile. When someone gives you an ID, right, you question the ID itself. You now want to check with systems that confirm with Home Affairs to see if this is the person that is appearing here. It's so good now we have smart IDs.
IDs, yes.
Previously, the ID, the Green Book ID, they will take out the picture and put the picture there. And the only thing, we will rely on the person that is sitting there. They will have title deeds, but it's very difficult to have to make a fake title deed. It means that person must be colluding with other role players, which I cannot mention.
Let's give Home Affairs, Department of Home Affairs, a round of applause for the smart ID.
For the smart ID. Thank you, Department of Home Affairs with the ID.
Now, it makes sense.
It does.
You know what? Now you can put a picture on the smart ID.
You can't put a picture. And you know what I love also with the smart ID? They have a signature. Ne?
Yes.
That signature is appearing on the smart ID. Now, if I want to check if you are really the real owner, I even check that signature if it's matched. It's matched. Because most of the time you will really sign the same way. It will not be very different. So we really try and check. We check Home Affairs, we check almost everything. But title deed, if anyone at home who has an original title deed, who has a title deed and you want to verify it's original, go to the last page where it says the Registrar of Deeds Act, whatever, it must have a seal. When you touch it, it's a seal.
Yes.
It's coat of arms.
Yes.
Or some of them it's just it's a stamp, but it's a seal. Most of them it's a seal. You can feel it.
See it.
That's what we want to see. But we also check records. but where we would have failed, really the mind was active.
The mind of the crime, darling, I just learned that from you. You can't copy. Okay, there's this thing I had, Tshepang, the flips. What is that? Can you please give me some information and my viewers that are watching? Because I've heard about it, but I was like, you know what? I'll have Tatelo attendees on set. Tell me more about it. As we are having crash, today, we are sober because of
just a little bit of crash, my friend.
Crash, darling, I must be crashed. Before you go far, let me pour for myself. Okay.
FLISP, my friend.
Yes.
I see it making a difference every day in my practice. I don't want to lie.
It's making a difference.
It's making a difference in people's lives.
Oh, wow.
In a sense that FLISP stands for Finance Linked Individual Subsidy Program.
Okay.
It's developed by the Department of Human Settlement.
Okay.
So what happens with FLISP is FLISP will either, it has its own requirements. It's a subsidy.
It's a subsidy.
It's a subsidy.
I hope
it's a subsidy. It's a subsidy. The objective of FLISP was to make sure that it reduces your monthly mortgage loan repayments. So it will depending on your finances. It finances household. Okay, these are the requirements. You must be 18 years and older. You must be a South African citizen. Your household must be earning between 13,000 here, but I know it's not 13,000. It's below 13,000. The maximum is about 18,000 per month. Maximum, the household must be making about 18,000 per month and less. 18 and less. And then you must be a first-time home owner.
Oh.
So what it does is once you qualify, they subsidize you. So they will give you a certain portion that will be paying directly into the bond. Now let's say your bond was going to be 8,000 per month. With that subsidy, it reduces your monthly installment to maybe like 5,000.
Yeah,
depending on how much they would have injected. We've seen approvals for FLISP that were about high. Some are 30,000, some are 40,000, some are 50. It's a subsidy. So depending on the number of dependents that you have, depending on your approval, depending on how much you earn per month, they pay that subsidy. It's calculated by them. I cannot tell you how much you will get, but there are factors that they would look into. That amount that they give you, that you qualified for, let's say it's 50,000, they are going to take that 50,000 and then they will pay it directly into your bond.
So it's anyone, you don't need to work for.
You must be working.
Anyone.
You must be working, employed, and you must be earning less than 18,000 per month. You understand? And then afterwards, it's for first-time homeowners. You must be a homeowner for the first time. And then there's been a recent development that we've seen in our offices with FLISP. FLISP, if you qualify for a bond, or you have bought your property, you do have actually cash, but you cannot qualify you don't have money to pay transfer costs, or you don't have money to pay bond costs. FLISP has actually come into play to pay our costs. Even the bond attorney's cost.
But tell me now, can maybe I'm a first-time buyer.
Yeah.
Then FLIPS comes on board to assist me. Then maybe I want to buy again.
It won't assist you.
It won't affect me buying again.
No, it won't affect you buying again.
Okay.
You can buy again, but you can only benefit once. It's a government subsidy.
Oh,
it's
so
a government
you can work
subsidy
anyway as long as you are permanently employed and you 18 up to
18 or older.
Or older.
Yes.
Wow. Nizwileke babukela makhaya uchazile uTshepang from Tatelo Attorneys that there is FLIPS. FLIPS is a government subsidy that assists me and you who are first-time buyers.
First-time homeowners, yes.
Yes. Oh yes, and then you can it's up to 18,000. Your monthly salary.
Your monthly the household income. So they have a way in which they will be looking at the household income. It must be less than 18,000.
18,000.
Yes. So if you are married in community of property, they'll obviously want your spouse's salary advice and all of that. So it has to be lower than it used to be 22,000. It has been reduced to 18,000. But I don't want to lie. I see it assisting a lot of people. I mean, if you can't afford cost, they are paying for your cost. And if you can afford cost and you qualify for 90,000 example. Imagine that goes into your bond. It reduces your monthly installments.
Wow.
That is great. Can we give Human Settlements a round of applause for FLISP?
Hello, you know we are giving a round of applause. We started with Home Affairs.
Now you're giving the department.
Thank you guys. My friend, it's always a pleasure to have you.
I know.
And you are a resident.
Of course.
So the nice thing is that if something might come, and I'm like, okay, please come and help me and my viewers.
Okay.
On that note, is there any advice I give my viewers before we say goodbye?
I think I have touched on a lot of issues. The main thing I want to say is that Tatolo Attorneys is available for you guys. Please do contact me on 012-880-3831, 071-831-8795. If you want to send me an email or have a query, you can send it at info@tatoloattorneys.co.za. Thank you so much and stay blessed.
You know what, on that note, we hope Crash give me and you an opportunity to spread the word.
Thank you.
Far
Thank you.
far. On
Thank
that
you.
note, let's say goodbye.
Goodbye.